My lord, kindly, my lordship recalls my lord, those Section 9 applications, but post-award. My lord, your lordship had kindly my lord, allowed me my lord, time my lord, till this week. My lord, I have not received instructions my lord, that I can, my lord, these matters my lord, can be withdrawn my lord, with liberty, as your lordship had done in those 4 matters.
So we'll keep it for.
You know, they're already in the list my lord, today. It can be my lord, dismissed as withdrawn with my lord, liberty to file. My lord. They're all in the list, my lord. Dismissed as withdrawn my lord, with liberty my lord, to take, my lord, as your lordship had done in the last.
Yes.
Next week.
All right. Yes, they are in the list.
Well, these are all post-award Section 9. My lord, there are 5 more matters, my lord, which are not my lord, post-award. Those my lord, are appearing in the list today. My lord, maybe move it on Friday or Monday. My lord, they are in the list. My lord, these 5. Monday, my lord, if I can. I'm grateful, my lordship.
So may I have your lordship's kind leave to mention an application under Section 36(2).
I'm late by online.
It's a 600. This matter, I'm for the petitioner. He is the respondent. 600 crore award. Presiding arbitrator has not even passed her award as yet. The remaining 2 arbitrators have passed an award and saddled foisted liability of 600 crores. Not any day, because this is within 2 years they'll file for execution, not even put me on notice. Any day next week, if your lordship would consider. Normally I say I'll take 5 minutes. This one I'll take 20. This one will take a little time.
But this is that same matter where they have filed a Section 29A, which is coming up on 26.
That's another aspect of it. You know? That is for the mandate of the. If my learned friend wants to take that point, it augurs to my advantage.
That is that 2 arbitrators have
Yes,
passed.
yes, same.
Presiding arbitrator, we were to file the 29A.
When is that coming up?
On 26th August, madam.
26th August.
Yes, madam. That 29 is
26th.
coming, my lord. Not as it was listed, my lord.
Well, possibly.
26.
All right. Probably be, I don't know, but.
We'll have this also on the 26th.
But I don't need this to be clubbed really, because it will be on a completely different aspect. But 26 possibly will be a holiday. Your lordship needn't be troubled by us on that day. So 25th, 27th, 24th, any day on next week. Lord.
Lord, then kindly have it next week, because in anyway, I leave it to this court, my lord. I won't make that request.
Have it on 28th.
Please.
28th. Lord, 28th, we have, I think, Raksha Bandhan, my lord. So
27th, my lord.
27th is my execution day.
But
can we have it in first week of September, my lord, if my friend doesn't mind?
Then we can have it on 2nd September.
Yes, my lord. We can.
Second.
Come back on the second.
Grateful.
Hand over the.
Give the hand.
Very good.
May I have the leave to mention, my lord, it's only for some precedents in a matter. This has been appearing every Thursday. So in an execution award passed, money has also been deposited. I have filed an application for withdrawal of the money by putting in a bank guarantee. But if your lordship give some precedents, that's all.
Shiv, I'm the award holder in this matter. Yes. My learned friend is mentioning.
I am the award holder. You are the award
The
debtor.
award debtor. Yes. My Section 34 is also pending, your lordship. I am the newly engaged advocate in this matter. Yes. I would highly appreciate. I'm being led by Mr. Neeraj Malhotra. He is based Delhi. He is a Delhi advocate. He will be flying down from Delhi to argue this matter. If my lordship can fix any date and keep my Section 34 application along with Section 36 application, your lordship.
Then we'll see.
Oh,
Your lordship.
I have, my lord, leave to mention item 68 and 109. Lord, I am for the petitioner in both cases.
Item
68 and 109. 107, I'm sorry, my lord. 107.
Yes.
My lord, I am being pushed into insolvency without any just cause. So, my lord, I want to, my lord, deposit whatever is the demand, whatever your lordship feels, to save myself there. I'm being very candid. There are disputes and then we'll go to arbitration and we'll not fight it out. Because the law as it now stands is that we'll be completely finished. I believe Mr. Sinha's for the other side.
Yes, but I didn't get any. I find some mail was sent. But
Doesn't matter.
Yes, Mr. Sinha.
My lord, whenever your lordship fixes, my lord, hearing, but
Permissible, my lord.
whenever you can.
Take, my lord, 10 minutes maximum.
Not sure of that, but whenever your lordship.
No, no, but I'll be short, my lord, and I'll deposit the amount, which is at least 5 crores. Or I'll pay them if they are ready to accept it without prejudice.
There's a lot more, my lord, to this matter than
Yes, yes.
he
So, my
already.
lord, I'll be
The
very
best part of
candid.
Mr. Chaudhary, my lord, is he makes everything sound so innocuous. Lord, that's the beauty. Everything is extremely
No,
innocuous.
I must, you know, I'll be very candid. He'll come and say there is NCLT. So I am saying it beforehand. If I'll have to survive, next date is 25th. Only way I can survive the present condition of the law is that I have to, my lord, ensure he doesn't have a debt. So, my lord, I'll pay him without prejudice and then take it back in the arbitral reference with interest, if my client's case is good enough.
We'll have it, probably on Monday then?
Yes,
Monday.
Monday.
I'm grateful.
I'm grateful to you.
Go for it. Great.
For judgment, item number 1.
For the petition.
In view of the above, this court is satisfied that a valid and subsisting arbitration agreement exists between the parties in terms of clause 5 of the sublease agreement dated 4/7/2008, and that the disputes sought to be referred have not been shown in the manifestly and expressly non-arbitrable so as to warrant refusal of reference at this stage. All contentions raised by the respondent, including as to non-arbitrability, severability of claim, waiver, acquiescence, estoppel, and the effect of the proceeding under 1962 Act, and before the DRT are left open to be urged before the learned arbitrator, who shall be at liberty to decide the same in accordance with law. Accordingly, so and so is appointed. Just, Sinha, just ask her to check the names and all that because
Very well.
before I sign it, just check the names. Yes, Ms. Rashmi.
Second item.
For judgment, I'm not 2. I'm for the petition. In view of the above observation and the grounds recorded herein above, this court is of the considered opinion that disputes sought to be referred arise out of the contract dated 28/8/2020 and are covered by the arbitration clause contained therein. Accordingly, this court is of view that the present case is a fit case for appointment of an arbitrator under section 11(6). So and so is appointed. Amitesh Banerjee is appointed. Just check, Ms. Rashmi, just check the names and all. Check the name of the counsel.
Non-commercial matter. New motion section 11 item number 1 AP 406 of 2021.
This is my application. Let's first decide his application so that we can finish this. Otherwise, this will be kept pending. Yes.
I was compelled to file this application, Lordship,
Yes.
because initially we have filed the wakalatnama on behalf of the respondents. That advocate on record is not cannot present. So that I have to file this GA. I have mentioned in my pleading, Lordship, in the application.
Page.
In my prayer I have mentioned, and in the pleading also I have mentioned, Lordship.
Yes, tell me, where have you mentioned? What have you mentioned? Yes, sir.
In my prayer page, paragraph number 12, I have mentioned, in aforesaid premises on the interest of the justice, answering respondent prays to before this humble court, graciously pleased to dismiss it and paragraph number 6.
Yes.
Not present on Lordship, I have mentioned. So that Lordship, I have filed the GA to file a fresh vakalatnama and item number 406, the main matter.
What is there in paragraph 6, sir? Where is your file? You come to the court without the file.
No, Lordship.
Then?
Paragraph number 6, Lordship.
Your GA is listed. Where is your application?
Application I have filed, Lordship. Soft copy.
Where is your application? Where is the copy of your application? You have come to the court without the application which you are supposed to argue.
No, Lordship. I should not. I'm tendering apology for that. Somehow it has been mistaken. Paragraph number 6 of my application, Lordship.
The present application has been filed by the respondent seeking a recall of the order dated 11th August 2026 passed in AP number 406 of 2021, whereby the right to file affidavit in opposition has been closed. This court observes that the petitioner has come to the court without the copy of the application and is arguing the matter from his mobile phone. This court, while order dated 9th December 2021, had granted time to the respondent, to the petitioner, to file his affidavit in opposition. Till date, no such affidavit in opposition have been filed by the petitioner. The petitioner has slept over his rights to file affidavit in opposition for the last 5 years. Full stop. This court, while order dated 28 July 2026, by order dated 11th August, by order dated 28 July 2026, granted one last opportunity to the respondent, to the petitioner, to file his affidavit in opposition within a period of 1 week. Full stop. The same was not done by the petitioner. Full stop. On 11th August 2026, there was no appearance on behalf of the petitioner, and no appearance on behalf of the petitioner. Neither any affidavit in opposition was filed on behalf of the petitioner. Full stop. Keeping in mind the conduct of the petitioner and the fact that the petitioner has failed to file his affidavit in opposition since the year 2021, his rights were closed. Full stop. It is submitted on behalf of the respondent that Section 11 application concerns dispute arising out of an agreement for sale dated 23rd July 2014, and the respondents have substantial objection to the maintainability and the petition as it is submitted on behalf of the petitioner that Section 11 application concerns so and so dispute, and that the said application is not maintainable and is not maintainable, full stop. The petitioner further states that he has already prepared his affidavit in opposition, but could not file the same as the advocate on record was not traceable, full stop. It is further submitted that when the matter was taken up on 11th of August 2026, he failed to take notice of the listing of the matter, and thus there was no representation on his behalf, resulting in the closure of his rights to file affidavit in opposition. Full stop. Having considered the explanation furnished and in the interest of justice, the order dated 11th August 2026 is recalled. Let him file it so that we finish the matter. And the recalled to the limited extent and that it closed the respondent's right to file affidavit in opposition. Full stop. The petitioner's right. The petitioner are permitted to file the affidavit in opposition within 1 week from date, subject to compliance with all requisite formalities. The application is allowed with a cost of rupees. How much? How much?
Leave it up to your lordship.
As you lordship.
5,000.
Lordship, one liberty. Liberty to file a fresh wakalatnama in the original appeal.
The petitioner is granted liberty. His application with petitioner, otherwise he will respond. Is granted liberty to file his wakalatnama and
Only wakalatnama.
you file your wakalatnama. Why they are not accepting it? You don't need liberty.
While advocate is not present, so
You have to
no
give-
objection is required, lordship.
No, don't give that. You deal with the erstwhile advocate and file your
He is
wakalatnama.
not traceable. I have mentioned in the petition. That is the difficulty, lordship. Otherwise, I would have filed the opposition earlier.
Not traceable. She has disappeared.
I don't know, lordship. He is
What do you mean not traceable? She's a
filed.
lawyer practicing in the court.
Don't-
Record the details and file it. AP will appear after 1 week.
Yes.
Give a date so that we can finish it. Be a dispute.
দিয়ে দেবে হবে
ये सुनो
ডেট দিয়ে 25
अगर petitioner है ना उसमें कर दो the respondent has filed the present.
25
মেসেজ
Respondent has filed the present application.
after 1 week.
25
Change is not required.
ডেট
Deeply.
Oh, then we'll change. Then we'll have.
I know him, but he's a criminal lawyer. Not
Yes, yes. Then we'll have a retired judge.
That's what I thought.
So, my lord, may I make one submission? It's a joint submission from both of us. But if we come to a consensus, if we can suggest a name, both of us,
Yes.
my lord, I have to take instructions and come back.
Tell me.
My lord, Mr. Sinha has given a certain name. He's-
Former chief justice of our court.
My lord, kindly allow us, we'll just come back and come. I just need to take instructions from my advocate on record before I make any.
I'm not making a consent order.
Oh, my lord, then it is, my lord.
I'm grateful.
Very well, my
A
lord.
retired judge who's
I thought not because this.
Very well, my lord. It's, as my lord pleases.
because the amount was not
I understood.
given in there, and I,
Yes, how could you not?
Mr. Sinha, I have no idea about what is the value of any property.
Very valuable land, which.
First of all, I don't even know where the land is. So I have zero idea about unless it's quantified in your petition, I can figure it out. Otherwise,
But we also found out from the bank's claim, when this land was.
but I tried to figure out from the record. I couldn't. And areas, for me, every area is the same area.
That's why I thought that.
It
Thank
would be
you.
my lord's pleasure to appoint Justice Bhattacharya.
Yes, that's what he's saying.
My lord. Grateful, my lord. Grateful.
That's the name you have suggested,
Yeah.
right? He's-
Very well, my lord. Grateful.
वो एक order देना तो judgment
One
First.
one turn, one turn. One. Oh, one.
One. नाम बताएं? What was the name? Jyoti. Yes, call on.
You mentioned item number 3.
Right.
My lord, I'm appearing for the petitioner. I've been recently briefed. I'm yet to receive all the documents, and moreover, I have instruction to brief the learned additional advocate general. I need some time because hearing was continuing before the erstwhile bench, and Honorable Justice Shampashaka was pleased to release the matter by order dated 6th of August.
Yes, Mr. Sen.
My lord, 4 weeks time may kindly be granted.
Learned counsel for the petitioner states that he has been recently engaged
Recently, and I
He
have
has
not
been
yet received
recently
the whole
engaged.
document, the whole file.
in the present matter and seeks time to get himself acquainted with the matter. Seeks 4 weeks time to get himself
4 weeks.
acquainted with the matter. Let this matter be listed after 4 weeks.
Grateful.
Now 4.
I appear for the award holder, my lord, in this one.
My lord, ask application under section 34, my lord.
Yes.
My lord, we have made a submission, but my lord, now we have to start, my lord, afresh. With regard to my lord,
Transfer matter.
Yes. My lord, from Justice Sarkar, my lord. It was heard extensively. Petitioner had
oh,
already.
this is before the regular bench now, my lord. I'm sorry, my lord, now my lord has to, we have to travel, my lord. Praying for sitting state of
It's always a pleasure. Mr. Nair.
no, my lord.
I'm being led by Mr. Ghosh. He's there online.
And especially your briefing counsel.
No, my lord, he is, I don't know. He is, my lord, quite, my lord,
No, he's very
good, my lord. He's quite good, my lord.
absolutely. But he comes up with very interesting points,
My lord, those points, my lord, I filtered. I haven't, my lord, I'm not letting them, my lord, go further ahead, my lord, than, my lord, me.
When do you want it?
My lord,
Kindly fixes any date, my lord.
any date, my lord, end of August, first week of September, whatever, my lord, is convenient to my lord.
Kindly gives a date.
Rest of the parties, let this matter be adjourned to
Hearing matter. So it's a hearing matter, my lord. So
monthly list of September,
My lord, monthly list of September, my lord, the matter.
pushes back.
Yes, my lord. Pushes back, your lord.
my lord,
Kindly
whatever is convenient, my lord. I'm
give
not,
the
my lord.
date, my lord. Then, my lord, there's a.
See, these are hearing matters. Let's
Yes.
have it after vacation.
My lord, I'm being led by Mr. Ghosh.
My lord, whatever.
Yes, Mr.
My
Ghosh.
lord, my only request is let it start. My learned friend argued for 3 days, 6 days nearly, and then Justice Sharkar released it.
Instead of 20
Our
minutes, 15
clients
minutes,
are a
I
bit.
can't help it. I'm not as quick as
Yes.
Mr. My lord, that I can.
We,
No, it's
Especially,
not
my lord, when
your
I'm
fault.
asking for setting aside of the award.
6 days.
September, my lord, will keep it like your lordship's September monthly list
Whatever, my
or
lord, monthly is over.
1st of September. Always a good date.
Of September.
Should I copy
Yes.
of that?
Yes,
Monday.
ma'am.
Let it be monthly. We'll see.
7th September.
7th September.
Any
We'll try. We have given a date, na? We'll try to do.
Grateful.
great.
7th month. Keep it on 21st September.
21st
Yes.
September.
Yes. Grateful.
21st.
Grateful.
Lord, sorry, so sorry, my lord.
So tell,
21st, my lord, can it be 22nd or 23rd?
let's 23rd?
23rd.
23rd.
I'm grateful.
Grateful.
Those corrections, you made it in the order. Have you made the corrections?
Yes.
Give it where? You have made it, no?
Yes. Yes.
18. MP Electro. Date 20th. Ratul.
Great.
Six.
And for the respondent.
For the petitioner. Lordship, item number 6 and 7, the case name should be Hooghly Mills Project Limited instead of the Hooghly Mills Company Limited, Lordship.
That's all.
Lordship.
6 and 7 both, huh? Correction.
Company limited look here. New motion at number 8.
My lord, item number 8, I beg to appear on behalf of the petitioner. My lord, kindly recollect, your client has, my lord has instructed me to go through the client that whether they are willing to pay the arbitrator and the tribunal fees or not. They are willing to pay and they have sent their mail to the higher ups so that it can be paid for approval.
Has it been paid?
It will be paid within 2 weeks.
Come back after it's paid. After 2 weeks.
Yes.
Ensure it's paid.
It will be paid.
Come back after it is.
Oh, great.
We'll keep it after when do you want? How much time you want?
3 weeks. 3 weeks.
Keep it after 3 weeks.
Because it's a company. Great.
Nine.
My lord, I appear for the petition, my lord. This is my period of service and notice of motion. My section 29A application, my lord, on 24th November 2024, my lord, the arbitrator was appointed. Readings were completed on 13th August 2025. Thereafter, the matter was reserved for order on 18 December 2025, but sadly, the award was not given. We had given the payment to the arbitrator within 20th February 2026. I do not know whether the respondent has paid or not. I will kindly see the arbitrator has now been elevated to Honorable Judge of this High Court. Now,
then you have to move an application.
But 29A6, my lord, during this pendency of this application, this had happened. The elevation has happened during the pendency of this application. But I'm only seeking that the new arbitrator be substituted and from the stage of the
in
argument
29,
stage.
you want in 29 to be substituted?
29A6, my lord, it grants.
It can.
And I can show the minutes of the.
Who have you served?
On the Eastern Railway, my lord, on the respondent. And I do not even know whether they have paid the money because we have written to the London arbitrator, no reply was
Who
given.
appears for Eastern Railway generally?
Previously, one Modujana was appearing, but now I hear that he has been appointed as a state panel advocate.
Get the lawyer concerned. Get the concerned lawyer. There must be a standing counsel or somebody for Eastern Railway.
Very well. I'll come back. Kindly keep it after a week.
After a week.
I'm allowed to order be passed if it is service.
Affidavit of service taken on record. None appears for the respondent. Let this matter be listed on next week.
Deep obligation. And the
But do you have the prayer in this application?
No, I do not have.
That's a problem.
I can file a supplementary affidavit with the prayer, my lord.
Then you
because it
withdraw
has
the
happened
file.
during the pendency.
Then you withdraw this application, file a fresh application.
The petitioner is above say 875, my lord.
How does it make a difference? You have, at least the prayer has to be there for this court to pass.
In the supplementary, I can file and pray for that. Because
Supplementary,
in that during the pendency, it has happened, my lord. It
that's
is
all
not
right. Then you withdraw this application, file a fresh application. Mention it, I'll keep it.
The only difficulty is the time period, my lord. It has already been 1 year over, my lord. Kindly grant us till week. I'll file a supplementary affidavit with it with that prayer of substituting under section 29A6, my lord.
File application. It's the same thing. You file one application or you file supplementary.
Take time, my lord. Commercial site scanning, again uploading takes time, my lord.
Ten.
Your Lordship, my application under section 29, Your Lordship, second extension. Lordship, the first extension was granted by this court on 18th of August. The mandate of the arbitrator is expiring on the 20th of August, Your Lordship. The application is within time. The arbitration is at the final stage of arguments.
First paragraph of the petition. This court by order dated 28/8/2023 appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 31/1/2024 and with the consent of the parties, the mandate was extended till 6 months for a period of 6 months till 31/7/2025. Thereafter, this court by order dated 18th August 2025 extended the mandate for a period of 1 year. Full stop. Learned counsel for the petition submits that the matter is at the stage of final arguments. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Considering the substantial progress made in the proceeding and in the interest of justice, this court does not find that there has been any intentional delay on part of the arbitrator or the party to meet the ends of justice, the mandate is extended further for a period of.
We've prayed for a year, Your Lordship. Respondents' arguments are left, then the claimant will give reply and
Your Lordship, we appear on behalf of the respondents. We are just supposed to commence our arguments.
6 months should be good enough.
But Your Lordship, it's a substantial amount of paper. I'm told substantial amount of paper is this. The award might be taken some time.
Your Lordship, the date has been it's in September. Whatever Your Lordship pleases, Your Lordship. I'm not coming in the way.
If it requires, we'll come back. But my instructions are that the
For a
hefty
period of 6
set of papers were to be argued and gone into.
For a period of 8 months.
Great, great.
আপনার নামটা দেবেন
New motion section 11, item 11.
11 application, my lord. Matter is being adjourned from January.
Settlement.
But nothing is happening. No board constituted. I'm pretty sure nothing is going to happen. My lords may kindly.
Well, so far the item 11 is first item is concerned. Board has been constituted. Notice has been served. This is my instruction.
My lord, my lord, first of all, my lord, conciliation is not automatic. It has to be in the agreement. It was nothing in the agreement by we accepted, thinking that something positive might happen. But the manner in which things are proceeding, my lord, I don't think. The 5 matters, not even the board has been constituted in the other 3 matters, my lord.
So for this matter, your lordship kindly peruse your lordship's order, my lord, 10th February 20.
Have you received this communication?
We have received, I think it's about 3 months old.
17th August. This. Give a copy at least to him.
Yesterday night I have been emailed this one. I think they have been served. This is so far the item 11 is concerned. I'm only in item 11.
Item 12.
We have,
yes.
12, I don't think so. It's all connected, same issue, my lord.
With regard to 12, sole conciliator is to be appointed because there is a monetary limit where DRB cannot be initiated. DRB can be initiated if it is above, contract value is above 10 crore.
Above 10
It is
crores.
just below 10 crore, so sole conciliator to be appointed. With regard to item number 12 and 14, this is the position of both these items.
My lord, but kindly come to page 55. My lord is having the first one or second? Any first one. First one. Kindly come to the last page. That's page 55. my lord. Last page. That's the extract of the general conditions of contract. The first paragraph, in the second paragraph, procedure for constitution appointment of DRP conciliator shall be as laid down in the contract agreement. None of these agreements, my lord, have these provisions, my lord. None of these agreements have these provisions. The DRP or a conciliator can be appointed provided the agreement has a conditions or a procedure provided therein.
So the first one, what is your?
Even there, this the agreement is silent on it. There is nothing. But since they have appointed, but what I was thinking, well, since these are identical matters, about putting together all 5 matters, about 13-14 crores of a single permanent arbitration would be appointed in one in order to avoid a conflict of award. All these matters can be disposed of by appointing the same person as the arbitrator.
So for this one, your lordship kindly peruse your lordship's manner order dated 10th February 2026. 10th February. They are not opposed before your lordship, my lord.
February and now we are in August.
As the respondent expressed a fair desire to attempt resolve the dispute before the DRP, as the case may be, let the matter be stand over adjourned 8 weeks. And pursuant to this order, my lord, this appointment has been made. Now they are coming. Time to time, matter has been adjourned. Now they are taking a different stand.
Adjourned at
This is
the instance of the respondent.
The first one,
Yes,
then we can,
dispose
in
of the
terms of the DRB, go for the resolution if you.
Let all this be adjourned, my lord.
All right.
See, if something positive is happening, well and good. Otherwise, my lords can appoint a.
So we'll stand it over for 2 weeks.
2 weeks, my lord.
2 weeks. Then I'm not passing any order.
My lord.
But your lordship kindly pass an order.
At least communicate this.
This one, your lordship.
If
Subject to my
learned counsel for the respondent has handed over a communication dated 17th August 2026.
I can take up the matter with your department, but you have not served it.
Indicating that DRB has been constituted.
In one matter, in first matter, item 11 matter.
Indicating that DRB has been constituted. Learned counsel for the petitioner states that he has not received any such communication. He seeks and is granted 2 weeks' time. A copy of the said communication. Give a copy.
I shall ask them.
A copy of this. Give it right now.
I have printed copy. I'll get it corrected.
A copy of the said communication is handed over to the learned counsel for the petitioner.
My lord, may I take it back and get a fresh copy and hand over to?
And is granted 2 weeks'
I'll
time
hand
to
over to
take
your lordship's office.
instruction.
I'm
List
gonna
after.
I'll just take a snap.
List after 2 weeks.
2 weeks.
But you hand over a copy to me.
I've taken it.
All right.
So that
Then
I don't miss it. Oblige.
Then, my lord, in that event, I may hand it.
yes, you hand over. Keep it on record.
Grateful to that.
Oblige.
After 2 weeks. Only 11. No, in rest of the matters,
12
it's
and 14 dollars, sole
after
conciliator.
just after
May all the matters be ordered appear joint.
the rest of the matters. This is only for 11.
11 minutes.
The rest simply adjourned.
Simply adjourned.
At the request of the parties, I'm just recording. At the
The
request
dates,
of
my
the
lord.
parties, let this matter be listed after 2 weeks.
If my,
Your
well,
Lordship,
if
only on the record the fact that with regard to item number 12 and 14, sole conciliator is to be appointed. That is my instruction. That's why, my lord, I'm placing
that's
that.
up to them. If my
He
lord,
is the
can I
sole
make,
conciliator.
can I make a request, my lord, for a fixed date? My lord?
Yes, yes. After you left, Mr. Sublease, we were giving a date.
My lord.
Great.
Item 16.
Item number 16, I have for the respondent, your lordship. The matter has been settled. Before the mediator.
Learned counsel for the parties submit that the matter stands settled before the mediator. The parties have entered into a settlement agreement dated 7/8/2026, right? 7/8/2026. Full stop. Both the parties shall abide by the terms of the settlement. Full stop. In view of the said settlement, learned counsel for the petitioner seeks to withdraw the present petition. The same is
Obliged.
17.
I was to cite some judgments. My learned senior friend can come.
Coming on the way, man.
The two issues have been raised, followed on the last occasion. One is the pendency of Section 8 before the civil court, where they had filed a suit. And on the basis of that, they said that Section 11 can't be proceeded with until the Section 8 is decided. But on the last day, I had shown Section 8.3, which says that it is no bar and arbitration can continue, even an award can be made, despite pendency of Section 8. The Lordship has passed a judgment on this. I've taken this at Agri Horticulture Society. I'm carrying this judgment. That judgment, Lordship has relied on a Supreme Court, where there was an allegation that there is no existence of the arbitration agreement at all. There also Supreme Court held that it can be appointed and there is no bar at all. Now,
that's what I was telling you that day.
Yes, but I thought Lordship is going against me on that one. That is why I thought I'll cite those judgments. But the second point raised, that needs to be addressed.
Let him come.
On his way. He's on his way.
Monday. Keep it for Monday.
Very nice. Well, he's on his way.
Yeah, Passover, I don't think so.
No, I can continue. He'll reach just in time. I'll cite two judgments. That's
all. Let him come. Monday, we'll keep it up. Monday. But keep it.
Great.
We'll finish it off on Monday.
Great.
Mr. Shanak, yes.
But may I then formally cite your Lordship's judgment and the Supreme Court?
Have you seen that judgment? Do you want to bring anything on record?
My lord?
You want to file your affidavit in opposition or anything like that?
No, we have exchanged affidavits.
We have exchanged everything else.
They did not take this point in the affidavit. That is, in any event, I'm not for once saying that they can't raise this point. Paragraph 6 and 8. Yes. And, but I'll only formally cite, I'll not placing the paragraphs, it's your lordship cite. But may I cite this, the Supreme Court decision which your lordship had relied on? That is 2010, volume 2, SCC 486. Paragraph 9 and then 12 and 13 talks about the...
Will appoint an arbitrator.
My lord?
Will appoint an arbitrator.
No, my lord, can't be.
But
In
then-
this case, it can't be. I'll
may I-
distinguish it. Kindly take up, my lord, the provision itself. Well, let him. He
But
says he has
if,
not.
if my learned senior friend wants to deal with the section 8 point, then he can. Otherwise, I'll proceed on for forgery aspect.
Forgery, my lord, in section 11, very well.
They raised. I did not raise. I said that it is.
We raised
They
in
raised the
appropriate
point.
forum, not in section 11. We filed the suit.
Yes, you can place your judgments and.
Yes, my
So
lord.
you want to argue first and then he'll place his judgments. What do you want?
If my land, very well, let my landed friend complete.
But my learned senior friend cited Rajia Begum of the Supreme Court 2026, which says that if there is serious allegations of fraud and forgery, arbitrator cannot be appointed. Now, that has been distinguished in subsequent judgments by the Honorable Bombay High Court and the Himachal Pradesh High Court. May I cite those decisions?
Supreme Court judgment, distinguishment.
Citing a Supreme Court.
Yes, the Supreme Court judgment, I'll distinguish on facts. But in the Rajia Begum case, there were two parallel two courts expressed an opinion that there is serious allegations of fraud and forgery. And there is immense doubt as to whether the arbitration agreement was at all executed or not. All those things happened before the issuance of Section 21 notice. At the first instance, when the arbitration agreement was brought to the notice of the aggrieved party, the aggrieved party said that no, there is no arbitration agreement at all. This agreement itself entire agreement is forged and fabricated. At the first instance, they took this point. Then Section 9 court refused relief on the basis saying that there is no arbitration agreement. The High Court returned a finding that there is no arbitration agreement and there are serious allegations of fraud. It is only in those circumstances that the Supreme Court held that there are serious allegations of fraud and forgery and apparent from the face of the record, ex facie evident, then the court will not appoint an arbitrator and it is for the civil court to decide whether the agreement was rightly executed or not. But in the present case, the respondent has relied on that agreement. He has said that respondent has said that the agreement was executed. I've shown your lordship the paragraphs in the plaint as well as in the reply to the Section 21 notice. They show me as a partner in the balance sheet on the basis of the deed. The firm obtains loans from the bank showing me as a partner on the basis of that deed. Then suddenly when the disputes arose and I invoked the arbitration clause, they said that no, there is no arbitration clause at all. Why? Because they think that I have not executed the arbitration agreement. My signatures are different. Respondents are saying that the plaintiff has not executed the agreement, where the plaintiff is saying that he has, she has. But in those circumstances, my lord, it is.
What are you showing in this Bombay High Court paragraph?
But in the Bombay High Court decision.
Which paragraph?
Yes. Kindly see, this was a Section 8 case.
Yes.
Kindly see paragraph 6. Yes. This is the contention, the facts.
Yes.
The plaintiffs therefore contend that there was no concluded contract between the parties in the form of the agreement, which is relied upon by the defendant. According to the plaintiffs, the agreement in the possession of the defendant was obtained by fraud or misrepresentation, and that the plaintiffs 2 and 3, being out of the country, could never have signed the agreement dated such and such. Now, my lord kindly then takes paragraph 13, where they rely on the Rajia Begum case of the Supreme Court. Therefore, Mr. Such and such would rely upon the judgment of the Supreme Court in Rajia Begum, and in particular reliance upon paragraph 15, 20 to 24 of the judgment to contend that when an allegation of fraud and forgery or fabrication is made with regard to the very agreement that contains the arbitration clause, such a dispute would fall outside the realm of arbitrability and ought to be examined by the jurisdictional courts. Now, the court frames issues in paragraph 16. The first issue is relevant in our case, whether in view of the allegations of fraud, the disputes are not arbitrable. Now, what kindly sees one of the operative portion. For paragraph 18,
yes,
20 and 22. The law declared on implications of alleged fraud on arbitration agreements has evolved across judgments. Clearly, the law on arbitral tribunals being empowered to deal with allegations of fraud has been distilled and articulated in very clear terms since the earlier position obtaining from N. Radhakrishnan, where the Supreme Court took the view that where fraud was alleged in the books of accounts and records of the partnership firm, it fell in the domain of courts to repel a Section 8 application. Then paragraph 20. In Ayasami, the Supreme Court held that the mere allegation of fraud would not dispel arbitrability. It is only in cases where it is found that allegations are very serious that the Section 8 court may ignore the arbitration agreement and continue with the proceedings. Even the existence of the arbitration agreement itself having been obtained by fraud was kept within the ambit of potential non-arbitrability. Then paragraph 21 and then 22. The clear position in law is emphatically summarized and set out by a 3-judge bench of the Supreme Court in Deccan, repelling the case for not being referred to arbitration, where it was argued that an arbitral tribunal could not be called upon to cancel 3 written instruments, and that when there is a serious allegation of fraud, the arbitrator's jurisdiction gets ousted. But may I place reliance on the Deccan judgment, which has been quoted in this paragraph. We have in our judgment in Avitel laid down the law on invocation of the fraud exception in detail, which reasoning we adopt and follow. The said judgment indicates that given the case law since Radhakrishnan, it is clear that Radhakrishnan as a precedent has no legs to stand on. If the subject matter of an agreement between the parties falls within Section 17 or involves fraud in the performance of the contract, as has been held in the aforesaid judgment, which would amount to deceit, being a civil wrong, the subject matter of such agreement would certainly be arbitrable. Further, we have also held that merely because a particular transaction have criminal overtones as well does not mean that its subject matter becomes non-arbitrable. We have no doubt that Sri Navarre is right in his submission that there is no averment that the agreement and deed of confirmation were not entered into at all. But here, in our case, they have admitted execution of the agreement. Then, kindly see paragraph 22. This emphatic declaration of the law by a larger bench of the Supreme Court leaves no manner of doubt on how the allegation of fraud made in this case should be assessed for its impact on the operation of Section 8. Evidently, the Supreme Court has ruled that fraud in inducing a party into executing a contract as set out in Section 17 of the Contract Act or fraud in the performance of a contract would be in the nature of a civil wrong and is eminently arbitrable. Then paragraph 24. The reliance upon Rajia Begum is of no consequence to the facts of this case and is distinguishable. Noticing multiple judgments on the facet of fraud and arbitrability, the Supreme Court on facts found substantial and cogent material to cast serious doubt on the genuineness on an admission deed. In that case, the Section 9 court had expressed a strong prima facie finding against the existence of an admission deed, based on which interim protection was declined. Denial of interim relief was challenged, and a special leave petition against such denial was also dismissed by the Supreme Court, leading to finality of the prima facie assessment by the Section 9 court that the existence of the arbitration agreement was itself in grave doubt. Therefore, it was held by the Supreme Court that this was a relevant consideration for the Section 8 court and the Section 11 court when considering whether or not to refer the parties to arbitration. There was already an order of the Supreme Court. In the facts of that case, both the trial court and the first appellate court also returned concurrent findings that allegations of fraud in that case were serious, and the original copy of the admission deed was not even produced before the writ court, which in exercise of its supervisory jurisdiction under 227, dislodged the two concurrent findings on the existence of an arbitration agreement, and ignored the view of the Section 9 court affirmed up by the Supreme Court. It is in this context that interference by the writ court was held to be incorrect by the Supreme Court. Now, paragraph 27. That apart, for all the denial of the existence of the agreement, admittedly, monies have been received by the plaintiffs, which is consistent with the very instrument whose existence they now seek to deny. Plaintiffs want a bargain different from the executed instrument and seek a refund of monies with interest. Therefore, the contention of the agreement was not executed and the bargains therein were not contracted does not inspire confidence. Then, Malad, the court goes to deciding the other issue and referred the parties to arbitration. They have taken advantage of this agreement. They have admitted the existence of this agreement, at least the execution. Now they say that the previous agreement still operates with a separate person. Which separate person has come before the civil court and says that I have retired.
And 2010 SCC.
Sorry,
Vijay Kumar Sharma.
Vijay Kumar Sharma,
The one I have relied on.
yes, my lordship has relied on 2010, volume 2, SEC 486. There is also one judgment of the same distinguishing Rajia Bekam. See, judgment of the Honorable Himachal Pradesh, High Court of Himachal Pradesh. This was a Section 11 case. Yes. Paragraph 5. In the reply filed by respondent numbers 1 to 4, the plea has been taken that respondent numbers 2 to 4 had not signed the alleged retirement deed and they specifically had denied the signatures attributed to them in Annexure P1 filed with the petition as being fabricated. It was also alleged that the petitioner had failed to append the original retirement deed. Plea has also been taken. Petitioner was only an employee of the respondent number 1 and not a partner. Then, paragraph 9. In such circumstances, this court is of the considered opinion that there is a tacit admission of the existence of the retirement deed at the very outset. The written reply filed now is only an attempt to muddy the waters and introduce a defense that cannot be permitted, as parties cannot be allowed to change their specific stand taken earlier. Now, paragraph 12 is where the Rajia Begam's case has been considered. Placing reliance upon Rajia Begam's case would not be justified as such in the peculiar facts and circumstances of the case. In that case, the apex court had noticed that there were 2 proceedings before the High Court. In one proceedings, directions had been issued to resolve the disputes to arbitration, while in the other proceedings, the High Court declined to appoint an arbitrator on the ground that the existence of an arbitration agreement was in serious doubt. It was noticed that the subsequent order passed had been upheld by the apex court, bringing finality to the assessment made with no subsequent change in circumstances. In these circumstances, the apex court concluded that the doubtful existence of the arbitration agreement is a relevant consideration while examining an application under section 8 and 11. The said judgment is not applicable in the peculiar facts and circumstances, as there is no such finding by this court or any other court doubting the correctness of the retirement deed. Now, then the court appoints an arbitrator. These are my respectful submissions. There are no serious doubts as regards the allegation of forgery and fraud.
Well, let me start distinguishing. First, Milord, kindly see Milord, Himachal and Bombay. Milord, on the reading of Milord, the facts, I could not find Milord challenging the arbitration clause, challenging the deed itself. There was a suit filed and is pending. I could not find that. Therefore, Milord, how far Milord these 2 judgments are Milord applicable, my Lord will consider on the facts of the case. Now, Milord kindly takes up, Milord will kindly see Milord the fact. None of these judgments, Milord, say Milord on the challenging that particular partnership deed and the arbitration clause, the leveling Milord fraud, Milord the suit has been filed nowhere. Now, Milord kindly see your Lordship's judgment. Milord, APCOM 117, which my learned friend had relied upon. Kindly see Milord paragraph 6. However, the learned counsel for the respondent submits that the respondent had already instituted a title suit number such and such before the first civil senior division at Alipur, wherein an ad interim order of temporary injunction has been granted. It is submitted that the application under section 8 of the ad is pending adjudication before the court. Therefore, the present application is maintainable. Milord, subject to correction, kindly do not take me amiss. What were the facts? Whether the arbitration clause was challenged, nothing recorded. Nothing recorded. What was the facts of that suit? Whether it hits Milord on the jurisdiction of the civil court, nothing recorded. Well, we are completely in Milord in dark. What are the actual facts of this case? Now, Milord, kindly see Milord 8.3.
Yes.
Kindly see, my lord, 8.3 starts with a non-obstante clause.
Yes.
Notwithstanding that the application has been made under subsection 1. Here is a case where subsection 1 has been made and the issue is pending before the judicial authority. The arbitration, kindly see the next word, may be commenced or continued and an arbitral award is made. Therefore, it is directory and not mandatory. The word is not shall, it is may. It is may. Now, my lord, kindly sees, my lord, what is the relief claimed for. Whether, my lord, in this case, it can at all be referred to. My lord, kindly comes to, my lord, page 78. Kindly see, my lord, page 78, my lord, reliefs of the plaintiff.
Yes.
Kindly see with the very first prayer. A decree for declaration, the signature and the signature of the defendant number 1 and 2 of the deed of partition dated July 1, 2024 is not genuine. The said deed of partition is invalid and void in the eye of law. I have, my lord, challenged the deed itself. Therefore, my lord, kindly, my lord, visualizes the situation. Today, my lord, lordship appoints an arbitrator. Arbitrator proceeds in its own motion. My lord, tomorrow, my lord, my suit is decreed and it is declared the deed is void. My lord, there will be, my lord, conflict of judicial decision. In this case, my lord, whatever may be the concept, my lord, language of 8.3, that's why, my lord, the legislature thought it fit not to make it, my lord, mandatory. That, my lord, that is, my lord, that's why may was used and not shall. It is directive. It is not in every case, my lord, the same, my lord, the law laid down, my lord, it has to depend upon the facts of each case. My lord, kindly appreciate today. I get a degree. Today, my lord, this partnership deed, my lord, it is declared, it is a product of fraud and it is a void document. And my lord, the arbitrator, my lord, passes a award. My lord, may I ask myself, which party will gain from it? Which party will gain from it? My lord, it will lead to a, my lord, convergence of, my lord, divergence of, my lord, judicial decision. Well, now, my lord, kindly takes up my learned friend had repeatedly, my lord, harped upon one point. I have admitted them as a partner. I have shown them as a, my lord, partner in the, my lord, in our accounts. Now, my lord, on the last occasion, my lord had to, my lord, mark that page. My lord, it is when it was in the year 2024 and 2025 before 1st of July 2024 when we, my lord, did not discover, till that time we did not discover the fraud. My lord will kindly, my lord, recapitulate. My lord, kindly see their affidavit in opposition. My lord has already marked that page. Kindly see, my lord, page 48 and 49. I'm sorry, my lord, rejoinder. They're rejoined. Sorry, my lord. It's 48 and 49.
Yes.
Now, kindly see dates before, my lord, that discovery of fraud. Yes, we even if, my lord, in our reply to section 1 notice, my lord, we said that we were under impression that Vivekanand Kejriwal was doing everything. He will get your signature, his wife's signature and his mother's signature done. And when we actually got that document in our hands, we inspected and found that those signatures are completely different from earlier signatures. Therefore, my lord, then we discovered the fraud and, my lord, we resisted them. And, my lord, filed the suit. Suit, my lord, prayer is specific, my lord, relief I have claimed for, my lord, against the defendant and, my lord, against the, my lord, defendant and regarding, my lord, voidability of the, my lord, partnership deed. My lord, whether in this case, my lord, considering the language of 8.3, my lord will kindly considering these judgments which my lord learned friend had, my lord, relied upon, whether it is, my lord, it will be, my lord, the expedient, my lord, to refer this matter to arbitration at this stage. Because, my lord, the judgments, my lord, which my learned friend I have read out, my lord, nowhere, my lord, it said, my lord, the suit was filed. Nowhere. None of the judgments. Even, my lord, and my lord's judgment, my lord, I have recorded, it doesn't see what was the reliefs in the plaint. None.
You have admitted to the execution.
Okay, great.
Great.
Yes.
18.
These are two matters where the proposal was sent. They have received it, but I have been told they have not accepted. I have been told by the learned counsel from the respondent, I'll withdraw it and I'll seek liberty to file afresh.
Learned counsel for the petition.
Respondents.
Learned counsel for the petition seeks to withdraw the present petition.
She will give me the
with
liberty to file
to
afresh.
file appropriate proceedings in accordance with law. Dismissed as withdrawn with liberty.
Both 18 and 19.
18 and 19 both.
নামগুলো দিয়ে Twenty. Not 20. Epicom 474 of 2026.
They have been served.
Lordship, service is incomplete.
Last time also it was incomplete. Serve them. Learned counsel.
For R1 it's incomplete. I'll serve on that.
Learned counsel for the respondent.
This is the second service.
Affidavit of service taken on record. Learned counsel for the petition states that R1 has, respondent number 1 has not been served. She seeks and is granted. How much time?
3 weeks.
3 weeks time to serve upon respondent number 1. Only R1 has not been served, right? The rest are served. List after 4 weeks.
Twenty-one.
Lordship, this is the second service on R2. It's incomplete again. There's insufficient address.
You have to get his address. Learned counsel for the respondent seeks and is granted. Affidavit service taken on record. Learned counsel for the petition states that respondent number 2 has not been served. She seeks and is granted for the time of 3 weeks to effect service upon respondent number 2. List after 4 weeks.
আগেটা 2 weeks ছিল আগেটাও করেছি
Lordship, service has
22.
been refused in this matter.
Yes.
Yes, tell me.
Lordship, loan cum hypothecation dated July 15, 2020. Page 13.
You have the previous order which have been passed. There are some.
Gotcha. The payment has been received after the settlement agreement.
Show me that order.
SO is page 74.
We have passed similar orders. You have any copy of that similar order which has been passed earlier? Get that on Monday. Monday, not today, Monday. In your matter only we have appointed.
Yes.
$23.
Track report is inconclusive. It doesn't say whether it has been delivered or not. I'll serve again. It was
Affidavit service taken on record. Respond number.
R1.
Learned copy by the petitioner states that petition is granted. Same 3 weeks time to time.
নামটা দিয়ে 24.
I'm for the petitioner.
I'm for the respondent, my lord, I'm delayed. My lord, your lordship gave directions for filing of the affidavit. My opposition, I was only able to serve, my lord, yesterday. I have it in my hand, my lord.
I find the reply, your lordship, within 1 minute.
Affidavit of opposition filed by the respondent.
My lord, only respondent.
Respondent is taken on record.
2 weeks time.
Learned counsel with the petitioner seeks and is granted 2
2 weeks time.
2 weeks time to file a reply to the said affidavit of opposition. List after 4 weeks.
Grateful one.
I'm grateful.
4 weeks. 2 weeks reply, 4 weeks again. Again 4 weeks. 25.
Lordship, when the service is complete, I'll get the similar order on Monday.
The problem in this is
Assignment. Lordship, we have intimated about the assignment and demand notice as well as the invocation notice. It was written there and those has been delivered upon the respondents.
but he is not a party. He has not made a single payment.
No,
That's the only
not in
difficulty.
this one. But they knew about the assignment agreement.
All right, but
They never objected to it.
they have never accepted also. They have not made a single payment.
They have not made any payments in
Any
this.
payments.
Not even before the assignment.
It's your Monday. This no,
Lordship, let it be open. Let the issue be open to be considered in the arbitration.
Monday, it seems.
Grateful, Lordship.
Number 26.
Your Lordship, 26, 27 matter. On the previous date, this matter was taken up. Your Lordship directed us to reserve because the previous service returned is no such person. Similar thing happened. It is pertinent to Joshua. It is pertinent to mention, Your Lordship, the notice under section 21 was served on the same address. It was delivered, it was received by them, they acted upon them. But now, as on the previous date, the endorsement is no such person in the address. We're praying for a direction of substituted service, Your Lordship.
Affidavit of service taken on record. Learned counsel for the petitioner states that the section 21 notice was served on the same address. Full stop. So the service report indicates that no such person stays on the address mentioned by the petitioner. Learned counsel for the petitioner prays for substituted service. In the facts of the present case, the said prayer is granted. Let the service be effected by way of a paper publication, one English one. How much time within a period of 3 weeks?
3 weeks, Your Lordship. We could do it.
3 weeks or 4 weeks?
4 weeks, Your Lordship.
How many respondents are there?
There are 4 respondents, Your Lordship.
Granted 4 weeks after 4 weeks.
26, 27 to action. 26, 27 to action.
Same. 27, give this affidavit of service.
Submitted.
Same.
Same respondents, same parties.
And now 28.
My lord, this is my section 14 application where the learned arbitrator has, my lord, withdrawn from the reference. In all these three, my lord, matters 28, 29, and 30.
My lords, I am for the respondent. My lords, this matter was taken up last Wednesday when I had sought for an accommodation on Mr. Debraj's house ground.
Yes.
My lords was pleased to keep it at 2 o'clock. Subsequently, this matter wasn't taken up due to some resolutions. My lords, he had indicated, I believe, to my learned friend that he's not available during the first half today due to his daughter's admission. He'll be
No, but
here.
I had a word with him. My lord, he suggested 2 appellate names, and my lord, we weren't agreeable. So we concluded that whoever lordship may, my lord, appoint, because now, my lord, the learned arbitrator, my lord, is recused. Mr. Sahu's presence was necessary for, my lord, some, my lord, coordination in by consent suggesting a name for, my lord, the replacement. Now there, my lord, unfortunately, my lord, we have failed, my lord, to arrive at a consensus.
Let Mr. Sahu be there. We'll keep
Very-
it Monday.
Very much.
Grateful, my lords.
Not today, Monday.
And now 31.
Yes,
My lord, I appear for the respondent.
who's there? Section 11. Stand for the petition in the interest of justice, adverse order that effort. Just after. Keep it next week. After 2 weeks.
My lord, I'm sorry, my lord. My lord, am I audible to your lordship?
No.
My lord, am I audible to your lordship?
He is running. Which matter?
Item 30.
My lord, item 31, my lord.
Yes.
My lord, I'm sorry, my lord. I was trying to, my lord, connect, but could not get connected, my lord. My lord,
Yes.
kindly permit me. But on previous occasion, my lord, they had appeared, my lord, and sought for a service. My lord, we had
We have served, and this is.
though, my lord, we had served again because it's a commercial division without prior service, my lord, filing cannot be done. But we had served again, my lord, subject to my lord's wisdom, my lord. Today, my lord, somebody else appeared. Now, my lord, if it commences, my lord, would it, my lord's wisdom to permit me, my lord, to come on Friday?
Monday.
If, uh,
Monday.
Monday, then, my lord, kindly keep it on Wednesday.
My lord, he is consenting for the appointment of the arbitrator.
Lord, kindly pass an order or take it up on Monday, Wednesday, whenever my lord is convenient for my lord.
He's
Already. Oh, if my lord, they are consenting, my lord, then so.
my lord, it's
My lord, then kindly comes to my lord. The arbitration agreement, my lord, my section 21 notice.
Yes. Page.
Yes, my lord. My lord, page 303. My lord, the third volume.
Yeah.
My lord, I have raised, my lord, certain disputes and differences. My lord will come at page 310, where my lord will find, my lord, though not being exhaustive, my lord, I have given, my lord, what are the disputes and what are my claims in lieu of damages. There was a wrongful termination, and also, my lord, there were certain non-payments. And, my lord, there was a subsequent, my lord, though not in a way to, my lord, give a reply to 21. However, my lord, they have sent also a notice, my lord, claiming, my lord, they have also certain claims against me. My lord will find at page 313. And they have also, my lord, said that they would be, my lord, seeking for enforcement of the arbitration clause. Now, my lord, the parties are ad idem, my lord, there are meeting of minds. My lord, they are, my lord, expressingly, my lord, concerning that there are disputes and differences, my lord, which can only be decided. My lord, there is also an arbitration clause. There are also, my lord, attending circumstances whereby, my lord, and where under, my lord, the parties would, my lord, have considered, my lord, this it could be good.
The petitioner.
My lord.
May I make only two submissions.
Yes.
Lord, in the petition, my lord, they've raised several allegations against me. My lord,
I'm not getting into that.
No. That is up to the arbitrator.
All issues will remain open before the
My lord, kindly record that all issues, my lord, only to that extent.
petition under section 11(6) of the Arbitration and Conciliation Act 1990. Appointment of an arbitral tribunal to adjudicate the dispute and differences arising out of a contract dated 8th November 2019.
My lord.
Between the parties for hiring of heavy earth moving machinery bracket for HEMM bracket for removal of overburden at the KHO TTADIH.
My lord.
Open cast project at Pandaveshwar, India. The petitioner states that pursuant to the said contract, it undertook the work entrusted by the respondent, full stop. According to the petitioner, some disputes subsequently arose between the parties in relation to the execution of the contract and the claims arising therein, full stop. It is alleged that despite completion of substantial work, various claims of the petitioner remain unpaid, and disputes had arisen regarding the respective rights and liabilities of the parties under the contract. Full stop. It is the petitioner's case that the arbitration agreement contains arbitration agreement contained in clause 13
My lord.
of the contract was invoked by a notice dated 17/2025 under section 21 of the said act. Full stop. By the said notice, the petitioner raised various claims arising from the contract and called upon the respondent to resolve the dispute through arbitration. Full stop. Learned counsel for the respondent that they have counterclaim as far as the said contract is concerned and does not oppose to the appointment of the arbitrator in terms of the agreement entered into between the parties. Full stop. With the consent of the parties. Give a name.
My lord, any, my lord, these are claims are quite high, my lord. Any former judge of this court.
Justice Talukdar.
My lord, in the similar matter, my lord, any former Chief Justice, my lord, has Justice Banerjee, Justice Mukherjee, my lord, whosoever.
Subroto Talukdar.
Your junior is saying Subroto Talukdar.
My lord, anyone that my lord's kind wisdom permits. Anyone. Subject to my lord's wisdom, my lord, whosoever.
Justice. Yes. Any suggestion?
Lord, I have no suggestion.
Justice retired. Is appointed as the sole arbiter. Then 12/5.
Much
All
obliged.
issues are kept.
Well, all issues are kept. But the service may not be filed with kept with record.
Affidavit is on record.
On last occasion only it has been filed.
Okay. Grateful, my lord. Obliged.
No, this is my application, my lord. Service has been done on all the three parties, my lord. They have received the section 21 notice. They have replied, my lord. Today they are not appearing right now, my lord. But they have received the section 21. They have replied to that.
Monday?
And yes, ma'am.
Monday?
Can
Just inform the other.
yes, my lord.
Just inform them.
My lord. Number data আছে number phone করে দিয়ে একবার by mail also we have done, my lord. So all the persons has received, my lord.
All right. Tell me.
Yes, my lord. My lord, we had provided a loan. This is a loan come hypothecation agreement, my lord.
Page?
My lord, agreement is page number 11, my lord. The arbitration clause in page number 23, my lord.
This is
Yes, my lord.
31/1/2020.
Yes, my lord. Agreement dated 31/1/20.
Loan agreement
25, my lord.
2025.
25.
Loan agreement dated 31/1/2020.
Yes, 31/1/25, my lord. We had provided a loan of 35 lakhs, my lord.
How much?
Yes, approximately. They were to pay by 36 installment, my lord. They had paid 21 installments, my lord. Thereafter, they have defaulted.
Page arbitration clause.
Yes, my lord. Page 23, my lord. Clause 8, my lord. And clause 8.5 says the seat of arbitration is Kolkata, my lord. Well, once we have issued a section 21, it was sent to Yes, madam. Section 20. My lord, page 37, my lord. We had sent that, my lord, to our ODR institution, my lord. They had objected to that. Thereafter, we had sent a new notice, my lord. That is on page 45, my lord. They had replied to that, my lord, by letter dated April 10, 2026. They had not disputed the agreement, my lord. They had just said that it's a unilateral appointment. So thereafter, my lord, we have come before this court for appointment of an arbitrator, my lord.
Page 44 is the recusal. No?
Yes. Yes, but that the ODR,
Yeah.
yes, my lord. They had
45 is the fresh.
Yes, fresh section 21 notice, my lord. And at page 49, my lord, they had replied to that. And my lord, at page 51, paragraph 4, they accept that the agreement was executed and there is outstanding amount, my lord. Page 51, paragraph 4, my lord.
All right, take down. Affidavit of service taken on record. Despite service, none appears for the respondents. The petition. Paragraph I have preferred the present application under section 11(6) of the Arbitration Conciliation Act, seeking appointment of an independent and impartial sole arbitrator to adjudicate the dispute and differences which have arisen between the parties in relation to the loan agreement dated 31st of January 2025. 31st January, right?
Yes, my lord. 31st January 2025, my lord.
31st January 2025. Learned counsel for the petitioner states that the petitioner is a non-banking financial company, had extended a loan of rupees 35,25,000 to the respondent payable in 36 monthly installments. Full stop. According to the petitioner, the respondent paid 21 installments.
Yes, my lord.
21 installments and later defaulted in repayment. Full stop. As on 26th March 2026, a sum of rupees 3430,054.32 was claimed as outstanding, comprising, inter alia, principal, pending installment, interest, penal charges, and foreclosure repayment charges. Full stop. Page 45. Figure is here. Full stop. Learned counsel for the petitioner further states that clause 8 of the loan agreement contains the arbitration clause. Full stop. 8.1 provides for resolution of dispute arising out of in relation to the agreement, sanction letter, key fact statements and connected document by arbitration through a sole arbitrator appointed by an online dispute resolution forum. Clause 8.2 to 8.8 prescribe the ODR mechanism and provide, inter alia for electronic / document-based proceedings with Calcutta as the seat of arbitration and English as the language of the proceedings. Full stop. Clause 8.9 confers exclusive jurisdiction upon the courts of Calcutta, subject to the terms thereof. Full stop. The petitioner had initially invoked arbitration agreement by issuing a notice dated 15th of October 2025, and therefore the dispute to the ODR platform. Full stop. An arbitrator was thereafter appointed through the said mechanism. Full stop. The respondent, comma, through their advocates, comma, by letter dated 17th December 2025, objected to the constitution of the arbitral tribunal, comma, in particular, comma, to the manner of appointment of the arbitrator, contending that the appointment was unilateral and contrary to the settled principles governing unilateral appointment of arbitrator. Full stop. The learned arbitrator, comma, consequently recused himself by order dated 24th March 2026, while granting liberty to the petitioner to pursue their available legal remedies. Full stop. The petitioner thereafter issued a fresh notice under section 21 dated 1/4/2026, invoking the arbitration clause in the said arbitration agreement. Full stop. The petitioner, the respondent, replied to the said notice on 10th April 2026 and disputed the amount claimed subject to reconciliation, comma, and had expressed his financial constraint in repayment of the said loan. Full stop. Learned counsel for the petitioner states that the respondent did not dispute the loan agreement in their reply. Full stop. Though the respondent had not agreed to the appointment of an arbitrator in terms of the section 21 notice of the said act. Full stop. At this stage, comma, this court is required to examine the existence of a valid arbitration agreement and whether the statutory condition of exercise of jurisdiction under 11(6) are satisfied. Full stop. The loan agreement contains an express arbitration clause. Full stop. The dispute and differences have arisen out of the loan transaction and are plainly referable to the said agreement. Full stop. The objection of the respondent regarding quantum of the claim and the financial difficulty do not negate the existence of an arbitration agreement of the loan agreement containing an arbitration clause. Full stop. In view of the same, this court is inclined to exercise its jurisdiction under 11(6) of the said act and appoints so and so
I'm a junior member of the library.
Just give me a name.
Shonkurit Chakraborty.
How many years?
Yes,
How many years?
2020, my lord. Passed out in 2020, then did LLM from Jindal.
Mr. Give your
Nama number ta diyo.
so and so is appointed as the arbitrator to adjudicate the dispute between the parties. Said operator shall enter reference in compliance with section 12(5) of the said act. He shall be entitled to his remuneration in terms of the fourth schedule of the said act. A copy of this order shall be communicated to the learned arbitrator to take necessary steps with the aforesaid directions of the petition.
Yes. ও দিয়ে দিচ্ছে নাম দিয়ে সার্ভিসটা 30 রেসপন্ডেন্ট নম্বর 1 করে দেওয়া হবে Lord, similar matter, my lord. Respondent number 1 is not served, my lord. Is a company, my lord. It's a firm, my lord. And 3 and 4, 2 and 3 are the directors, my lord.
Serve respond number 1. Learned
2,
counsel
3 and 4 are the directors, my lord.
petitioner seeks and is granted 1 week. 1 week time to effect service on respond number
1 week, right?
1. Affidavit
Service
submitted
for
on
us.
record.
We'll do
Service
that.
report indicates respond number 1 has not been served. Learned
We'll
counsel
do
for the petitioner seeks and is granted.
Yes, 15 days. Fortnight, my lord. Fortnight, my lord,
2
fortnight.
weeks time to effect service upon respond number 1. List of expenses.
Much obliged.
Ready, report.
This is my application, my lord.
I am appearing for the respondent.
The service may be kept on record, your lordship. The petitioner had entered into an agreement for sublease with the respondent,
You're objecting?
My lord, I-
Yes.
entered into a sublease agreement on 29th of April 2022.
Page.
At page 15 of my application, page 13 of my application. I've entered into a sublease agreement with the respondent being the lessor in respect of a premises. It was preliminary used for warehouse and keeping materials, your lordship. Thereafter, subsequently, in terms of the said lease agreement, the lease was given for a period of 6 years with a rent of rupees 5,65,878 per month.
5,65,000. Yes.
The lordship will kindly come to page number 16.
I have.
Yes. That the terms, the rent has been stated in clause 2, subclause 3.
Yes, yes.
So thereafter, and addition.
Clause 1, subclause 3. C. 1C.
Yes, sir.
1C,
Yes, your
1C.
lordship. Clause 1 terms under clause C. And there was an agreed escalation of 5% every year. And thereafter, your lordship will kindly peruse that a table has been given for a period of 6 years. What will be the amount of rent payable along with the tax? Now, it was also agreed that a sum of rupees 33,90,468 will be paid towards refundable interest-free security deposit. Now, subsequently, the parties entered into an addendum agreement, which is appearing at page number 37 of my application. But we will kindly come to page number 39. The addendum was only to the extent that a modification was required in respect of installation of certain.
Is dated.
Your lordship, this is dated 20th October 2022.
29th October.
29th October. I stand corrected, your lordship. 29th of October 2022.
So what was changed?
My lord will kindly come to page number 39. May I read paragraph number 2? And whereas in terms of the said sublease agreement, the parties have discussed and mutually agreed for necessary modification of the agreement by adding the below mentioned clauses to the original agreement on the terms and conditions set forth in the amending agreement. Now, your lordship will kindly peruse clause 1. Yes. That the lessor, which is the respondent 1, shall arrange for modification of the said premises upon request by the client as per requirements of clients enabling to carry on its business activity on the premises upon mutual acceptance. So, your lordship will kindly come to clause number 2. What were the additional modifications? So, the modification requested by the client in this agreement indicates the petitioner before your lordship. HT works, masonry works, glass works for closure of ventilation, changes in civil structure as per layout prepared by the client, including walls, doors, flooring, painting, parking, and other changes required, and electrical works, including the load enhancement and setting up of transformer. So these modifications were accepted by the petitioner as well as the respondent. This modification was made, and it was also agreed that an additional amount of rupees 18,50,450 was to be paid as an additional interest-free security deposit. Your lordship will remember that in terms of the sublease agreement, the mother sublease agreement, 33,90,468 has already been paid towards interest-free security deposit. So for this modification, an additional sum of rupees 18,50,000 has been paid for these modifications, and these modifications were well accepted by the parties. Now your lordship will kindly come to page number 40. There is a table, your lordship, where it categorically states that if client hereby indicates the petitioner, if the petitioner terminates the agreement before 6 months from the date of lease agreement, then what amount he is entitled to towards refund. So my lord, there are 4 categories: when client terminates after 6 months, when client terminates after 2 years, and when client terminates after 4 years. So my lord will kindly come to row 4, clause 4. Client terminates after 4 years and before 6 years from the lease agreement dated 25th day of April 2022 entered between the parties. So admittedly, we have terminated the sublease agreement after 4 years. There has been breaches, and we have terminated the agreement. Now your lordship, these are the factual scenario which has led the petitioner to approach your lordship. Now my lord will kindly come to page number 34. I should indicate your lordship that the arbitration clause in the mother lease agreement. My lord, page 34, your lordship. Clause 22, that in case of any dispute or difference arising between the parties hereto in any of the matters under this agreement, or interpretation or implementation of any of the terms and conditions herein, the same shall be resolved through arbitration under the Arbitration and Conciliation Act. Any such arbitration shall be conducted by a 3-member arbitral tribunal, with each of the parties appointing their respective arbitrators, and the 2 arbitrators so appointed shall appoint the presiding arbitrator. The arbitration shall be conducted in English. The parties shall pay the cost of arbitration as may be directed by the arbitrators in the award. Now your lordship will kindly come to clause 23, that all the disputes arising out of the present agreement shall be subject to jurisdiction of courts at Calcutta, Kolkata. Now your lordship will kindly come to page number 48. My lord, we have asked the respondent to refund me the interest-free security deposit because we wanted to terminate the agreement, and we have categorically indicated that a stock.
Where's the arbitration clause in the other one? The amendment.
No, there's no arbitration clause in the addendum. Neither there is any kind
Malan, may I indicate?
There's a word used that
coextensive and coterminous with the principal agreement. It is not there, madam.
Malan, kindly come to page 41 once.
The terms of the earlier agreement will be read into this. Where is that word?
Malan, page 41, your lordship. Malan, no other change except as otherwise expressly provided in this agreement. All of the terms and conditions of the contract remain unchanged and in full force and effect.
Which contract?
Malan, page 41 of my application.
That's right.
Malan, this clause includes that except for the modification which has been entered into by the parties by executing this addendum, all existing clauses will
File your reply.
My lord, and invocation of the 21 notice has been against the directors, which is respondent number 2 and 3.
Whatever you have to take your learn it. The petitioner has preferred the present application under section 11(6) of the Arbitration Conciliation Act, seeking appointment of an arbitral tribunal to adjudicate the dispute that have arisen between the parties in respect of the sublease agreement dated 29/4/2022. Learned counsel for the petitioner submits that after the parties had entered into the sublease agreement and addendum agreement, amending the earlier agreement was entered into between the parties dated 29th day of October 2020. Learned counsel for the petitioner submits that the earlier agreement had contained an arbitration clause. Earlier agreement dated 13th May 2022 contained an arbitration clause with the seat of arbitration to be at Calcutta. First, he states that the said agreement, that the said clause was quoted to the subsequent agreement dated 29th October 2022. First, learned counsel for the respondent states that the present petition is not maintainable since the earlier agreement was modified and amended, and the subsequent agreement does not contain any arbitration clause. Full stop. He seeks and is granted 2 weeks, 3 weeks, 3 weeks time to file his affidavit of opposition, reply to the same if any within 1 week thereafter, list afterward.
grateful election.
1-4, right? $35.
With our application, my lord, we have solved them. 2 and 3 has received. One is saying the received left, but the advocate of the respondent number 1 has written a letter raise an objection regarding the appointment of arbitrator. That letter is with the petition.
You have to serve them, Mr. Pandey.
We have served them, my lord. One is saying received left, my lord.
Find the address.
But their advocate has written a letter. He is saying here.
Advocate's letter will not help you. That is reply to section 21.
Yes, my lord. That is reply to section 21.
That will not help you. Serve them.
I can serve their advocate also, my lord.
No, serve the respondent number 1. Affidavit of service taken on record. Service report indicates that the respondent number 1 has not been served. Learned counsel for the petitioner seeks and is granted 2 weeks time to effect service on respondent number 1. List after 3 weeks.
$36.
Basically, I am appearing for the petitioner. There is a certain dispute regarding the construction of metro railway. I am appearing for the contractor. There were some outstanding bills, the basic cause of action. But the agreement is at page 17.
Well, I am only taking an objection as regards the claims have become time barred, stale, completely stale. I would like to use an affidavit to point it out.
Let's hear him out.
Very good.
Stale, not stale, will see deadwood is a very
What the
difficult thing.
arbitrator will decide.
That's what I'm saying, my lord. Complete deadwood. And that's what I'll show one or two documents
Let's
from.
see.
My lord, the agreement, my lord, is at page 17.
Yes.
If my lord come to page 19, my lord, it specifically provides that the terms would be governed by the general condition of contract, GCC. Lordship has got clause 1, my lord, and then Lordship will find 1, 2, 3, 4, 5, 6th one, general conditions of contract. Lordship will also find, my lord, the same thing at page 21, the jurisdiction clause. Courts at Kolkata shall have the exclusive jurisdiction to try and dispute arising out of an agreement between the parties.
This is 2010.
Yeah, this was agreement was around 10. Now, my lord, if your lordship kindly comes to the then disputes arose, things are happening, payments made, everything. My lord, if your lordship kindly comes to page 187, it's in the second volume.
Yes.
Lordship, may I please that this letter? With reference to the above, your final escalation bill, undisputed, was scrutinized and computed as per norms of SOC's review census, which is passed on the escalation bill number 7. Since your final bill undisputed was for rupees 20, as against your claim of rupees 20, as per the GCC computation and as discussed with you, the amount of price variation of escalation for the period from August 18 to December 2018 is rupees 20. It is requested to you that an email dated 20 to send the tax invoices along with all relevant documents, but nothing has been received so far. It is once again requested to send the tax invoices to the escalation bill so that both the final bill and the escalation bill for the undisputed portion can be passed for payment. Your early action within 7 days from the receipt of the letter is solicited. Otherwise, the final bill will be passed for payment. This is, my lord, this is dated 19 December 2024. This is apropos. I wanted to bring this. My lord, I should also bring to your lordship the GCC, which is at page 49, the first volume. I'm sorry, I should have taken that to your lordship. Lordship will come to page 119.
Page
119.
119.
119.
Yes.
Clause 17.5. This provides for a two-stage first conciliation, and thereafter, if there is a failure, to go in for arbitration. If your lordship kindly take clause 17.5. I am not replacing the entire clause. It talks of conciliation, and thereafter, the lordship comes to 17.9 at page 121. 17.9, if the effort to resolve all or any of the disputes through conciliation fails, then such disputes and differences whatsoever arising out of the parties, arising out of touching or relating to the construction, manufacture, measurement, operation, or to the effect of contract or the breach thereof shall be referred to arbitration in accordance with the following procedure. Similar, it was the two-tier. First is conciliation, then is arbitration.
Yes.
Your lordship, can you take the second volume once again?
Yes, Mr. Banerjee.
196.
Yes.
By which the conciliation failed. This is recorded over there. My lord, if your lordship kindly comes to 5th of January 2026. Therefore, the contractors, if your lordship comes to clause 4. Lordship has got clause 4. Therefore, the contractor's prayer for conciliation is not acceptable in view of the above provisions of the contract. So this is failure of the conciliation. So till this stage, I could not have come before your lordships. Yes. So, as I was just saying, till this letter records that the conciliation has failed, I could not have approached your lordship. Yes. Yes, clause 3. And your lordship, in any case, the failure is not for on the ground of limitation or anything like that. Lordship looks at clause 3. It is on merit.
You were before the NCLT also.
So that happened that I've come out of it. That is not happened. Because I went into NCLT.
What about 17.4?
The moratorium was there for a period.
You couldn't. What does 17.4 say? The one which you are reading out to me, 17.5 and all that. What is 17.4? When were you issued the performance certificate? You could not raise the dispute within time. That's what they're saying.
No, but the rejection, lordship has seen when I showed you lordship, the rejection is not on the ground of limitation. It takes it on merit.
What else?
Because if going back to the failure of 196.
Yes.
Lordship sees 196 once again. I'm sorry.
190, 119.
No, 196.
196. The rejection.
Yes. This records the rejection. So over there, if your lordship sees, with reference to your letter number so and so, please note the following. Lordship has got.
Yes.
Yes. The final bill of the claim and its escalations were raised by your letter number so and so and so and so, so and so, so and so, respectively.
Why do your letter number so-and-so, dated so-and-so, informed their intention of referring the case to consideration at 17.5 GC. Next, performance certificate was issued on so-and-so as per clause 17.4. The GCC notice of dispute shall be served within 28 days of the performance guarantee.
So the timelines are important.
No, Miller, I showed you first the document which I showed to your lordship, Miller, when they asked me for the bills.
It's 2024.
If your lordship kindly comes back to Miller, 187, which I will not place with your lordship. This is 19 December 2024. That's when they asked me for the complete bills. Lordship gets the second last paragraph. It is once again requested to send the tax invoices for the escalation bill so that both the final bill and the escalation bill for undisputed portion can be passed for payment. Similar today, from that, so after this, my conciliation, from conciliation, rejection, thereafter my cause of action for the arbitration comes. No. Would we lordship, I should place the full letter to your lordship? No. Okay. What my learned friend said about deadwood, so that situation has not arisen earlier.
The breaking point has not come.
I think he didn't mean deadwood in that case. He just probably means that, the compliances have not been done in terms of the agreement which has been entered.
No, my lord, what I'm trying to say, my lord, the claims are completely stale. It has become a dead wood. And that will appear on the face of the documents which are there in this proceeding. It is not that something else has to be gone into for the referral court to come to this conclusion. On the materials before your lordship, it will appear that the claims have become dead. That is what, my lord, my submission is. And that has been recognized. That is one aspect which a referral court has
Anything
to
else you want?
There would be a few judges I would like to, because on the proposition that for the 11-6 stage, this is not an issue to be considered, let it be considered by the arbitrator. I'm coming to. So, Millard, going back to, so basically, Millard, as on 19 December 2024, they are talking of payments.
Yes.
Millard,
Breaking point has not reached.
Millard, so they have, since the final bill of Rose so as you can see, so if Lordship sees the first paragraph that shows, with reference to above, the final escalation bill undisputed was scrutinized, computed as per the norms of so and was passed by so. Since the final bill is so, then as per this is the next portion. Then next is important portion is you are once again requested to send the forward. So till 19 December, this entire thing has been continuing. And they are only on the point that undisputed is also scrutinized, not payments. Similar, my humble submission is that we are yet to reach the point when it would be the breaking point, as my lordship says, on the for the thing to become. First and foremost, I would like to cite 2025 1 SEC. The citation is 2025 volume 1 SEC 502.
2025, right?
2025 volume 1 SEC 502. Well, I'll be relying on paragraph 47 to 54. দে না একটা কপি দে না কেন করছি পেয়েছিস তুই তাহলে খেঁচে খেঁচে করছিস কেন
I thought you can come back after a short affidavit. So these same judgments will have to be shown at the time of final hearing. Just trying to cut short your lordship's time, nothing else.
These are things I don't want to get into.
all points keep open করে arbitration চলো
Right.
6 করে দিই
At least make a submission so that I see.
Yes, but only one
You know that
Yes, but I have understood.
I generally don't give the right to file affidavit.
Yes, yes, I understand. I will show your lordship one document why I am saying this. Just one document. Your lordship will kindly take page 42, volume 1.
Yes.
This is the first time this claim has been made. Kindly see.
2019.
2019. And there they already say, your lordship will see, this is to bring to your kind note, aforesaid project has been completed, handed over, CPD is under defect liability period since 1st January 2019. We submit that having performed our obligation under contract to the fullest satisfied, we are now waiting for realization of legitimate payment. Next line, my lord, very important. We have submitted payment requests for such and such for the works executed following heads, which are detailed in Annexure A enclosed herewith. Next page, my lord. As evinced in Annexure A, GC has rejected some of our claims and they are yet to revert on some of them before 2019. Likewise, the KMRCL is yet to take decision on certain claims which are processed and recommended by GC. Unfortunately, that Annexure A is not part of this petition. Your lordship will kindly take this document, which is the full set with Annexure A. Kindly see, my lord, what is Annexure A to this? তুমি তো নিজে রেফার করেছো very well. Lordship will see Annexure A. All these have been rejected when 2017. All serial number 1 rejected. Kindly see remarks column denied by GC. What is the date, my lord? 20th of May 2017.
December 2019.
Then, my lord, so everything under the remarks column you will lordship will find 17, 18, 18, 18. Then next page. GC has recommended in principle approval. In principle approval, KMRCL has not given in 2019. And 2026, notice of dispute is coming, which is a section 21. So it's a long barred claim. Rejection, your cause of action or your cause to issue the notice of dispute arose in 2016, starting from 2016. If your lordship sees Annexure A. And my lord, the judgments are very clear. You cannot go on making demand notices to extend the period of limitation.
No, I'm not asking for demand notices. You have kept my pending.
Even I can, even if I keep it pending, that there must be a breaking point. The breaking point is 2019.
There were certain claims which were not responded to.
Yes.
Escalation. See, there are some which are denied. You read the denied part.
Now come to my serial number 6.
Yes.
Serial number 6.
Yes.
Is a recommendation by GC.
Yes.
But KMRCL has not honored the recommendation.
That's all right. Come to 8.
Yes.
Come to 9.
Yet to be responded by GC. That is when? 2016.
Whatever it is, I don't know whether any communication has been done after that.
That is what, my lord, I would like to show your lordship from these judgments. That
because if you see 8, 9, 10, escalation is 13. Escalation also you are saying yet to be processed. 11 is yet to be processed.
But if I have
That's
sat,
what I was asking.
no, but that point is, if I have,
This annexure A does not show that everything has been paid and all the claims have become
yes,
time
but
barred.
even if I have sat back from 2016, your cause of action does not go on till 2026 to make the notice of dispute.
Limitation and all other things can be looked
But
at.
I'll just show your lordship one judgment which clinches the issue, my lord, here.
Judgment.
Yes, but on this aspect, nothing else. My lord.
We are in the identity. You're looking at the number of the file affidavits.
Yes, my lord. Kindly see, this is 2024 5 SCC 358, my lord. Kindly come to, my lord, paragraph 65.
44 relying on geometry 20
ভিতরেই তো কোড করা আছে
44
kindly come to 64 65. Cause of action becomes important for the purpose of calculating the limitation period for bringing an action. It is imperative that a party realizes when a cause of action arises. If a party simply delays sending a notice seeking reference under 96 Act because they are unclear of when the cause of action arose, claim can become time barred even before the party realizes the same. Then Russell on limitation has been quoted. Kindly come to 68. Whether any particular facts constitute a cause of action has to be determined with reference to facts of each case with reference to substance rather than the form. If an infringement of a right happens at a particular time, the whole cause of action will be said to have arisen then and there. In such a case, it is not open to a party to sit tight and not to file an application for settlement of dispute of his right which had been infringed within the time provided by the Limitation Act, allow his right to be extinguished by lapse of time, and thereafter to wait for another cause of action and then file application under 11 for establishing it was not then alive and which had been long extinguished, because in such a case, such an application would mean an application for revival of a right which had long been extinguished under the Act and is therefore dead for all purposes.
These are all settled issues, Mr.
This is very settled, my lord.
Settled to the extent that your arbitration runs after your 21 notice, 3 years limitation is what the court has.
No, I am not saying
cause of action issue has been well settled. You go before the arbitrator.
Well, I am not on the aspect of limitation for 11. I am saying claims which you have raised in the notice of dispute.
That arbitrator will decide.
That cannot.
I cannot decide in 11.
Leave all issues.
Your lordship, kindly, my lord, I can't explain, my lord. The point is, there are two aspects of limitation. One is limitation of the claim and one is section 11 limitation. I am not on section 11 limitation. I am saying when you raise the notice of dispute, at that time itself, it was long dead. My lord, we are not on section 11 limitation. This judgment says that, my lord. If your lordship kindly gives me one minute, my lord. Kindly come to para 69. Your lordship will get this particular issue here. Kindly come to para 69. Yes. We once again go back to the facts, even according to the petitioner.
Facts of the present case. Even according to the petitioner, the dispute arose between the parties.
Is it para 69, your lordship?
Yes.
Yes. Here, your lordship will see disputes arose between the parties in relation to wrongful encashment of bank guarantee by letter dated 16 February 2016 and for wrongful imposition of liquidated damages such and such. We are at one with the learned ASG that this was the breaking point. What is more important is the fact that
because in the facts of the present case, the matter was different. That pertains to your bank guarantee. Bank guarantees have a limited shelf life. So that is the reason why it has been held that, the claims are dead. Because the
So-
shelf life is over, there's nothing else. But not
Number
here.
one, that is where. But thereafter, your lordship will see the next line here, my lord. The requisite amount was credited into the government account in accordance with instructions contained in letter dated 11th August. This was the end of the matter to say
Yes,
that.
because-
One second, my lord. Even thereafter, the petitioner kept negotiating with the respondent in anticipation of some settlement would not save the period of limitation. Here, what they did, they went on writing to GC. That is end of the matter in 2016.
Not at all.
But-
Mr. Sen,
My lord, kindly come to 73 once, my lord.
you see the facts of the case.
My lord, this is what has been
Logic will
held
not apply here.
in Geo Miller also. What had happened in Geo Miller is similar to this case. Claim is rejected or there is no response to the claim. So if you go on writing thereafter continuously for 5 years, that will not give you the limitation, my lord, save the limitation. My lord, kindly see, my lord, only once, my lord, 72 and 73.
Yes.
73. So here, my lord, the breaking point is when the bank guarantee has been invoked, encashed. My case, the breaking point is on those several dates when it's already been rejected.
Not rejected. Not rejected. It has not been rejected lock, stock, barrel.
But for some, it is kept, there is no response.
It's your fault.
Yes.
You keep something for 100 years.
So,
It's your fault.
So if I don't respond for 100 years and you come after 100 years, your claim will not revive.
If you have not decided,
Yes.
the claim is a pending claim.
It becomes a rejection, my lord.
How does it become a rejection?
My lord,
Mr.
that
Singh?
is what I would like to show your lordship, my lord. Kindly see, my lord. Negotiations may continue even for a period of 10
This
years.
is not
or-
negotiation. You have not acted upon those claims.
Yes.
You yourself say that we have not decided these issues.
So, my lord,
You are keeping it pending.
So you
If
will
it is-
you will wait for cannot wait for an indefinite period
They
of
have been
time.
writing to you. You yourself are writing to them that you please provide me in 2024,
But that-
November of 2024. you are
November
writing
of 2024, that payment has been made.
No, not
I'll
yet.
show-
No, the escalation has not been made.
No, my lord, that is, I'll show you.
Anyway,
Yes,
why should I get into this
No, my lord.
at the stage of section 11?
Then, my lord,
Why should I get?
I will have to produce those documents to show that these bills have been paid. And whatever is the claim now remains, that is already rejected.
We should send them out lock, stock, barrel. Let them file his reply in 2 weeks. We'll finish it off. Without reply, I'll pass an order. You know what will happen.
But I need to file a reply, my lord, to show your lordship.
I know why you need.
It doesn't give.
My junior is very agree that your lordship does not give opposition.
Arbitrator কাছে হতে হবে. Everything can be done before the arbitrator. Kindly keep
No,
the
no,
doors
not
open.
not in all cases. Not in all cases. My lord, your lordship will kindly
My
consider.
submission is your lordship can record that
He is there.
or let the
Limitation
arbiter-
point has sub decide everything.
You could seek instruction, Mr. Sen,
Not
and
necessary.
But this is not a general rule. I bow down to your lordship, my lord. But this
if
is
you push me to that, then I'll pass it.
no. I am what I am saying is, my lord, kindly allow me to permit to produce those documents. If your lordship is not satisfied on those documents,
Come with
we'll
the
have to go.
come with the documents on Monday.
No, those documents should be before the arbitrator.
Come with the documents on Monday. We'll see what are the documents.
Well, let me place a short affidavit. My lord, I'll show.
You show me the documents. Then you challenge my order.
No. Why should I challenge that order? my lord? No, my lord, there's no.
I'll pass an order. You challenge.
No, my lord, there's no question of challenge.
Come on Monday. We'll see. We'll examine the scope. We'll examine the scope. We'll examine the scope of section 11.
Well, I'll just file a short affidavit. My lord, kindly permit me to file an affidavit.
Why should we waste time of the court for filing affidavits? If the contract is admitted, the GCC
Absolutely,
is there.
I'm not on that.
I'll record all your submissions.
No, I
All your
understand.
objections.
But your lordship, see, well,
I'll deal with every objection of yours and pass it on.
but I will have to, I'll have to show some
You
documents.
seek instruction from railways. They should go before the arbitrator. Monday. Come with the document if I see anything. We'll decide.
Well, I will have to file a lot of documents, my lord.
Come with the document.
I shall.
Can he go beyond that particular letter?
Yes, that is
Whatever
Do I,
document. Yes.
Mr. Manager, do I need to
No, I'm not. I'm saying
at
asking
this
myself.
stage,
No.
at a section 11 stage, do I need to get into all this?
No, not at all.
But
Not
if your
at all.
lordship finds,
Yes, absolutely.
if your lordship find, it's not that the door is.
Absolute. I am not saying the door is absolutely true.
Yes, well, that's it. Well, that's what I want. That this even a small window should be there. If your lordship examines this,
You have done a lot of matters before. Have you ever seen the door to be closed?
no, I'm not. I'm saying door is closed.
We'll see. You
For
come back on
section 11, door is not closed. Well, section 11 code.
We'll see.
There may be a very small opening, but it is there.
Opening if
Opening for me.
No, opening for us to show.
Why are you resisting?
I am not resisting, my lord, but this is something which is on the face of it.
Who's briefing you?
Point before the arbitrator.
Let us, my lord, make an attempt to show that I can come through that small opening.
We'll see.
If I can't, and if I can't, I can't.
We'll deal with all that. Monday.
Well, instead of Monday, kindly give me a week. I'll file an affidavit. My lord.
No. Don't file. You'll file an affidavit in 1 week. We'll decide it. Good. You file it in 1 week. We'll decide the
Yes,
issue.
sure, one
Let them file their affidavit. It will be easier for.
Time fix করে দেবো।
We'll fix the time. The petition.
They are requesting for a little more time.
That is it.
1 week. File their affidavit. We'll finish it off. Why waste unnecessary time? We'll deal with all submissions. The petition has filed the present petition under section 11(6) of the Arbitration Conciliation Act 1996 seeking appointment of a competent arbitral tribunal. 3 arbitrators, huh? 3 arbitrators. Arbitral tribunal. In respect of the dispute arising out of the contract entered into.
The contract says 3, we can go in for 3, my lord.
For whatever you want. I'm not.
I would say
With the consent of the parties, this can be only modified. I can't modify terms of a contract.
all I was saying that
This can only be done with the consent of the party. This can't be done with the unilateral view of the court. Entered into by the respondent for designing, manufacturing, constructing, and commissioning the Central Park Depot of the East-West Metro, right? East-West Metro. Full stop. Learned counsel for the respondent states that the present petition is not maintainable and the same is time barred. Full stop. He seeks and is granted 1 week time to file his affidavit in opposition. Reply to the same, if any, within 1 week thereafter. List after 2 weeks.
But only one
Give a
thing.
date.
Petition is not. My submission is petition is not time bound. The claims are dead.
Learned counsel for the petitioner, respondent states that the claims of the petitioner are time bound.
The time date fix.
Lakshmi is fixing a date and time.
Yes. After 2 weeks, give a date.
Time then.
No time. Date.
September.
Sorry, second. कब का रखा?
टॉप जाना था।
Obligement.
Mr. Sen will be happy putting everything.
The law is settled. I am not on the proposition of law.
Absolutely,
But
law is settled.
But from the facts of this case,
on the facts of the case, only on the facts of the case.
you are relying on a bank guarantee proposition
No, my lord.
to convince me with the debt.
No, my lord. I'll tell you, lordship. That judgment say even after the amount was credited, thereafter, my lord, the parties tried to negotiate.
You started reading from that paragraph. It says in the facts of the present case.
Yes.
It is because it deals with a bank guarantee. And that is the reason why when the period lapses, then even the negotiation has been held to be a futile exercise.
Well, that is what I was trying to draw analogy here. I have rejected some.
Not rejected.
Not rejected.
No, but
You're not
but I'll show your lordship a
You're
judgment.
saying that if I have not rejected also, it should be assumed to be rejected.
Could have gone for conciliation
But
at that stage.
no, it's not a question of it's you have to wait for a certain period. But suppose there is a bill raised on me.
that ground.
I sit tight on the bill. There is 5 years I have sat tight.
No, communications are on.
That is the point. Communication.
You have not communicated your rejection of the claims on escalation, on cess, on lot of other issues.
But I have even paid them whatever I have accepted. But I have withheld this part. That means it is a rejection.
Not with.
But I'll come to it. I'll try to. But let me try. Let me try.
The same heading attack colors.
But could it appear in the same heading?
It does. It always does.
It's all
great.
My lord, next matter. My lord, next matter.
Yes.
I'm for the next matter. I'm for the respondent, my lord.
I am for
My lord, I was humbly seeking if this matter could be referred to mediation and the dispute can be resolved between the parties, my lord.
That
My lord, a lot of efforts have been made, my lord. I have to take instruction on that in that event.
Instruction come back on Monday.
Come on Monday, my lord.
If that can be referred. If he is willing to settle it, then.
So we have sat to almost 2 to 3.
My lord, I have spoken to this is the first time I've spoken to my client when he's come to the High Court. My lord.
Anyway,
I have that he's willing to settle the dispute. I think my learned friend. My lord, if he's agreeable, otherwise we'll fight it out.
Monday. Let him take instruction. We'll keep it
As
moving.
your lordship, please.
Settlement is right. Why shall I go for arbitration? Obviously not.
Monday.
I'll take instruction. What a Monday.